Hi there, this is Adam Botterill and Damien Grant from Tempest. We're here to do a quick video update on the Decmil NZ liquidation. So Damien, why don't you just give us a brief rundown for those that haven't seen what's been going on, what's happened on Decmil?
Well, what happened on Decmil? Well, we had the vote. So there's two parts. One, Mr. McVeigh did a video presentation to the creditors, and he told us what he has and hasn't been doing, which is quite remarkable. And then 2 days later, we had the vote, and everybody had to vote by either postal vote or proxy. And the vote to replace was won pretty comprehensively. It's about 128 people voted. There was about 28 people who voted to retain Mr. McVeigh and about 100 people, give or take, who voted to replace him. The problem was, and despite that, Mr. McVeigh remains in office. And he remains in office because even though a majority in creditors by number and dollar value, by a big margin, voted to replace him, Mr. McVeigh exercised his discretion, I guess, as the liquidator, and he cancelled out a whole pile of votes. Now, according to his analysis, there were 21 creditors who filled in proxy forms but had not provided a proof of debt. Now, most of those proxy forms would have been one that we had submitted, and we assume that's the case. We're a little bit surprised because we also had access to lots of proofs of debt, but we'll take Mr. McVeigh at face value on that there were 21 votes presumably voting to replace him that didn't have proofs of debt. And if that's the case, then Mr. McVeigh was correct in knocking them out.
Well, because you can't accept a vote if there's no
proof of debt.
Yeah.
So you must provide a proof of debt to the liquidator to demonstrate that you're a creditor. And so if you put in a vote but you haven't proved that you're a creditor, then you're out. Okay. Then there was 14 creditors with claims totaling $3.8 million that Mr. McVeigh also rejected, or he valued their claim at $1. So there's 14 votes, which he also were worth $1.
So that $3.8 million becomes $14 in terms of the
Correct.
dollar value mechanics of those creditors.
Yeah. And reading his explanation, it's a little bit unclear as to exactly why he did that or the basis upon he did it, but fine. Okay, all right. Then there was another 14 votes with $6.6 million, which he also rejected, possibly on the basis of there was some net off or some other reason why he was unhappy with the claim. So, he's knocking out about $10 million worth of votes. So, for whatever reason, they're out. Well done, Mr. McVeigh.
I mean, Damien, in your experience as a liquidator, would you go through such a process in advance of a creditors meeting vote here by postal? Would you or have you gone through such an extensive process to either reduce claims down, knock claims out, and so on and so forth?
No. So essentially what you do is you accept claims at face value because under Section 304 of the Companies Act, it's a crime to make a false claim. And indeed, when I was a liquidator of a company called Stanley in Torwood, there was something like 200 odd votes, and I don't believe that we rejected a single vote in that. We basically let everybody vote. I don't think there was a single creditor vote that we excluded.
Case, just from memory, in case that there were claims or there were votes where there was no proof of debt, we wouldn't have counted that.
But exactly the same thing. But it is, unless the claim was outrageous or obviously manufactured, then you don't typically exclude them. He then had 5 claims for what he said were unapproved variations. So again, pretty subjective, $1.4 million, knocked them out. And then he had 3 claims which total a total of $70 million. Now this is kind of an eye-watering number. So he had three creditor claims for $70 million. Now that's, okay. I mean, I must admit, I might have some sympathy for him those, but without seeing exactly what they were, he just said, right, $70 million, and he's knocking them out. So then we come down to the actual vote, right? So he had about $7 million voting to remove him, and that was, so he's knocked out something like $80 million worth of votes. And those $80 million for whatever, and we assume that they were votes to remove Mr. McVeigh. We don't know that for a fact, but I think it's a fair assumption. So he's knocked out $80 million worth of votes. He's still got 70 votes against him, totaling about $7 million. But he's then got 28 votes for him, and those votes come to $45 million. Now, here's the thing that's interesting. Decmil Australia, who was the parent company, claimed in the liquidation for $25 million. Now, under New Zealand law, that $25 million can be set aside. So
now, it's not set aside by the liquidator, but a creditor can apply to the court to ignore that vote, essentially, and put it to one side.
Correct. And in this situation, the court's almost certainly, not to assume what a court judge was going to do, but it's very likely that the courts would have set that aside. So we're down to $15 million worth of votes for Mr. McVeigh. See, even that I struggle, because when I look at the original liquidator reports, I struggle to see where that $15 million would have come from, because the total creditor pool in his original liquidator report was $40 million. So there seems
either you have either the accounts were not fully accurate. Yep. So you had some under-reporting of liabilities, or further claims had eventuated since the last financial reports.
Yeah. So but look, without transparency of what's going on, it's hard, and we should give Mr. McVeigh the benefit of the doubt there. But nonetheless, I'm surprised. So, so on that basis, in order to replace the liquidator, we needed a majority in number and a majority in dollar value. And in my view, we had a majority in number and we had a majority in dollar value. It's just Mr. McVeigh decided that there was $80 million worth of creditor votes he, rightly or wrongly, chose to set aside.
And that's materially impacted perhaps the outcome here.
Well, it's absolutely material. So even if you remove the $70 million for the three creditors and you allow all of the other votes in, on the surface of it, Mr. McVeigh would have been replaced if the related party Decmil Australia vote had been set aside. So look, so there are a couple of choices now here before us. So in a New Zealand setting, and certainly this has happened to me. I mean, I had a situation where the creditors voted to replace me, but I remained in office because there were related party votes in my favour. And in that situation, I offered to resign and hand over to another liquidator. And in the end, we did a deal. But the honourable thing to do for a liquidator in that situation is when the creditors quite clearly do not want you, and you are only remaining in office due to discounting other creditors or potentially related party votes, the honourable thing to do is to stand aside, because why should you be in there when the creditors don't want you? Anyway, that's not happening in this situation, and Mr. McVeigh has made that really clear. So, we've had a couple of conversations with people who may potentially take this issue to court and challenge it. We have no clarity on whether that's going to happen yet. That's something for the future. But here at Tempest, I don't think we have an appetite to go to court to challenge that. That's up to others. But we do have a cunning plan. So let's just talk about the retention fund, Adam, and talk us through how that might work.
Well, the retention fund in Decmil is quite interesting, because about a week or 2 weeks prior to liquidation, Decmil Australia transferred about $3.2 million into Decmil New Zealand's accounts, and as part of Mr. McVeigh's information session and his updates, he's indicated to the creditors that the Decmil group of companies operated as central treasury, with Australia having a central part in that. So that before liquidation, Decmil Australia has topped up Decmil New Zealand to the tune of $3.2 million, and the assumption there is that is for the retention amounts that were meant to be held on trust for those construction contracts.
Yes.
Now, Mr. McVeigh said he doesn't know exactly if it is retention funds. He wants to go to court and have the court to determine that issue. I guess as well he's indicated that he would like to be the receiver of the retention funds, so he can manage those and dole them out to the creditors that are due retentions. Now, our plan is to have a separate insolvency practitioner.
A New Zealand-based
Practitioner appointed to be the receiver and manager of the retention fund, and there are a couple of reasons why we would like there to be a separate receiver put in place there. I know there will be a little bit of inefficiency because McVeigh already has an understanding and some knowledge about the accounts and about the retentions, but our concerns are, one, that Mr. McVeigh spent quite a large amount of that money already.
$750,000.
Yeah, it's about 750,000 at the last update. That retention fund, or that funds that we think are retentions, has been depleted by about 750k on legal fees, and that excludes liquidators' fees.
That is good, and that was about a month ago.
Yes.
So at the rate he's going, he's churning through about $80,000 a week of money. And here's the real challenge. Presumably only a very small part of that money is actually going on issues that are related to retentions. So if the court comes around and says, Mr. McVeigh, that $3.2 million is actually retention creditor money, then he shouldn't be spending it. And in my view, he's going to have to pay it back. And so given that Mr. McVeigh now has a problem, potentially, then he's the one who's going to be making the application to the court, asking the question, is this $3.2 million retention money, or is it money available to the liquidator to do as he pleases? And it's, I'm pretty squeamish about that. I don't think that's the way that this process should work, given Mr. McVeigh's behaviour to date.
So that was the first issue. So regarding, is there an incentive for the liquidator to consider those to be general pool funds, or is it, ring fence for retention creditors? We want there to be an objective third party come in and say that this is going to be the way forward for retentions.
Yep.
And if Mr. McVeigh has a liability potentially in terms of funds being spent to date, then we'd like there to be someone to come in fresh and to work through those issues. And if there is the situation whereby funds have to be refunded, that's dealt with appropriately.
Yeah. So what we're doing now, for us to do that, we're going to need a lawyer, and this is not something that Tempest, we have in-house lawyers such as Mr. Bottle. This is not something that Tempest can use its in-house lawyers for. So we need to engage an external lawyer to do this. And so we're reaching out to the retention creditors and we're asking them to put their hands in their pocket at this point. We're going to be engaging Brent Norling from Norling Law, and just for transparency, Brent Norling used to work in this building as Waterstone Insolvency, a sister company's in-house counsel. He now runs his own law firm specialising in insolvency. So, transparency, we know Mr. Norling really well. He's a good lawyer. I'm sure we can get a really good deal out of him. But what we're looking for is, put it bluntly, we're looking for a $10,000 commitment from retention creditors. There is $3 million of retention creditors out there. And what we're saying to the retention creditors, and we're going to be mailing out a form, and we want the retention creditors to sign it and indicate how much you're willing to contribute to
and
this
Damien, when you say
exercise.
10,000, you mean 10,000 in total, not 10,000 from each.
No. Sorry, 10,000 in total. Yeah, if we get 10 creditors all chipping in $1,000, then we're home and hosed. If we don't get to that threshold, then we're not going to do it. But we actually think in this situation, I am really confident that we have an excellent claim here. Here you've got the liquidator who appears to be, we don't know, and Mr. McVeigh doesn't know whether that $3.2 million is retention fund or non-retention fund. He does not know that question.
But he's been spending it.
But he's been spending it. And if he doesn't know if it's his money to spend or not, then he shouldn't be spending
Well,
it.
it should be kept separate and not touched.
Yeah. So according to his report, there's $3 million worth of retention creditors, and he had $3.2 million given to him by Decmil Australia. So he had $200,000
to play with at that time. Yeah.
And he's and as of 5 weeks ago, he's already $500,000 over that, not including liquidators' fees. So this guy is somebody needs to restrain him. Hopefully, somebody will go to court to challenge his behaviour on the creditors' meeting, but that Tempest won't be doing that. So that's what we're asking you to do. We've done quite a bit of work here. We think we're in a pretty good position. We think that Mr. McVeigh's behaviour has justified us taking a really robust approach against this guy. And so what we would, but at this point, we actually need some financial assistance from the retention creditors to help us take it.
And everyone has an interest in that as well. If we can get another retention manager appointed that's going to look at this and properly work through the issues and respect that those funds are retention funds, then we feel that there'll be a larger return perhaps to creditors at the end. So there is a benefit in supporting that proposition, I would say.
Yeah, I think even if you're not a retention creditor, there's probably no point putting your hand in your pocket. But if you are a retention creditor, we can, I think, safely assume that if we do not appoint an independent receiver over this retention fund, the chances of you as a retention creditor getting anything more than cents in the dollar based on this liquidator's behaviour is pretty slim. So if you are a retention creditor, I think it's really important that you put your hand in your pocket and support us on this.
And we'll be circulating a letter and form shortly.
Yes.
So review that. If you're interested, fill it out, get it back to us, and we can take it from there.
And our contact details are down below. Thanks so much for watching.
Cheers for watching. Bye.